Good morning. Please be seated. We are here on our case number 1CACV140806FC, Bobrow versus Bobrow. I think I'm pronouncing that right by the bailiff's note to me. Thank you. All right. Counsel, as you know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve any time, though, you're in charge of keeping track of it by yourself. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful to you if you would give us your name and the name of your client. We have read the briefs at great length. We've studied the record. We've also discussed the case in our conference. So with that, sir, you may proceed.
Thank you, Your Honors. Al Arpad of the Al Arpad firm now for respondent, appellant, appellee, and so forth, Ken Bobrow, ex-husband. As you alluded, the briefs in this case are lengthy and thorough. Both parties filed all three types of briefs, and in reviewing them, I was a little bit pressed to find something that we hadn't fully addressed. But I've got a couple of points that I'll try to make. Hopefully I can spend a fair amount of this time answering your questions if you have any. The issues fall into a few categories, and a whole bunch of the issues for both parties involved a payment from Mr. Bobrow to Ms. Case now. Her name was changed as a result of the proceedings, so hopefully that'll make it a little easier. I'll refer to her by that name. Involved a payment that was supposed to be made on dissolution in accordance with a premarital agreement by Mr. Bobrow to Ms. Case based on the appraised value of a house located in Colorado. So we refer to that as the snowmass payment or the snowmass issue. Both parties appealed certain aspects of that. Essentially, as I said, the briefs are somewhat lengthy and somewhat complicated, but the issue isn't that complicated. Oh, and before I go further, if I could, I'll reserve about 5 minutes, if I may. Essentially, three positions were presented. There was Mr. Bobrow's position, which has always been follow the agreement as written. The agreement was stipulated valid early in the proceedings. The court found it valid. In Arizona, we follow premarital agreements if they're valid. The second position was the position of the trial court, which reformed a certain portion of the agreement. And Mr. Bobrow, of course, argues that the court should not have done that the court did not have a lawful basis to change the terms of the agreement. Ms. Case, I have previously said, wants to rewrite the agreement. She took offense with that in some of her briefs. So at any rate, I guess I'll say that she is arguing for a disposition on that issue that is somewhat of an improvisation based on facts that happened that were not anticipated, according to her, in the
Mr. Arpad.
Yes, sir.
The prenuptial agreement indicated that at the time the petition for dissolution was filed, that Ms. Case was entitled to a portion of the equity in the snowmass property, correct?
That's correct.
All right. And equity has a distinct meaning, right? Equity means the value of the property minus debt that may be associated with the property. Would you agree with that?
Yes, in general, no in this case, because equity was specifically defined in the agreement as the appraised value of the house minus a very specific loan. So, for example, if Mr. Bobrow had gone out and gotten a second.
I'm going somewhere with this.
Okay.
But you couldn't make an appraisal under the prenuptial agreement in this case because Mr. Bobrow didn't own the property at the time the petition for dissolution was filed, correct? correct?
No, you can appraise any property at any time, as far as I know, Your
Is there
Honor.
an appraisal in this record?
There is not an appraisal that was introduced into the record. There was an appraisal that was marked as an exhibit. Mr. Bobrow testified about it. It was in the joint pre-hearing statement, but since there was no contest to Mr. Bobrow's testimony, it was never introduced at the trial.
Oh, so when his testimony about the value of the house was based on the appraisal?
He actually testified in two places about two different things. The first thing he said was, here's what I think it would be, and I think he said 2.3, 2.4, something like that. And then he goes on and says, well, what's your position? His lawyer asked him, what's your position? Is it what we said in the pretrial statement? And he said, yes, it is. And that was, I think, 2.5. And so, and it's very clear in the pretrial statement that that was based on an appraisal. There was no cross-examination or further questioning of him.
But
and
he never referenced an appraisal in his testimony? Is that right?
I don't believe the word appraisal was used, Your Honor. No, that's true.
But the appraisal is in the record, just not admitted as an exhibit?
Well, it depends on your definition of record. It was not offered, so it's not, but it would be one of the marked exhibits if we brought up the stack of marked exhibits at this point.
Well,
And it's,
we have the exhibits that were admitted because that's the evidence before us. That was the evidence before the trial court. The trial court didn't to review that appraisal. No one has reviewed that appraisal.
that's true. No one has reviewed the appraisal because no one challenged Mr. Bobrow's testimony at trial. I will tell you, if the issue is that there is not adequate evidence to find out what the appraised value was today, then I think the remedy is to send back for a determination of that. That's done pretty regularly in family court.
This case has dragged off long enough.
It has dragged on an awfully long time, and Mr. Bobrow has been raked over the coals considerably in it.
Isn't the purpose of that section of the agreement, though, to allow both parties to share in the appreciation of the property during the marriage?
Appreciation or depreciation. It was chosen
Right.
to.
And Mr. Bobrow sold it and enjoyed a lot of appreciation. Why shouldn't we look back to that date and take that date as the appraised value? Because that's what was realized.
Because that's absolutely not the language of the premarital agreement. And it's not Arizona law on separate property. A particular.
But we're not talking about separate property.
We
because
absolutely are.
But the parties decided differently. They decided to treat it differently in their agreement.
Not at all. And this is important. The Snowmass house is listed as separate property right in the agreement. And the agreement says multiple times, consistent with Arizona law on separate property, things like, despite the change in nature of value or characteristics, it continues to be his separate property.
Right, but the agreement provided that she would get half of the equity in it upon dissolution.
And it's a defined term.
Why? Right. But why shouldn't we think, well, appraised value means what the property is worth, and we know what the property is worth because we know what it was sold for?
And one of the hypotheticals that I gave you in my brief is that if he had tried to get out of this payment by selling it to a friend of his for a very low amount, Ms. Case would be entitled to say, no, I'm entitled to the appraised value. The same thing happens when it ends up that he had sold the property 7 years earlier, put the money, the testimony was largely into his business, to some extent perhaps to pay expenses of the couple as they were married. 7 years later, he doesn't have the same money. Most of his business is around real estate. He had the use of the money, but it was his money. It was separate property, whether it was a house or whether it was transformed into personal property, cash, shares in his companies, whatever it was transformed into. It was his property up until the day the decree was issued, at which point she was entitled to a payment based on a defined term.
Well, actually, she was under the very literal language of the agreement. She was entitled to half of the equity in the property.
And equity was a defined term. That's correct. And it never
Defined
says.
term that could not be recognized because he had sold the property, and also could not be. There's no evidence to support it in this record of what that defined term was.
There is evidence, Your Honor. I could understand that there's not an appraisal. I would agree with you on that. Well, I'll move on. I think I've made the point as clearly as I can.
I think we're very interested in the gift question, and we're very interested in the ordinary and Is it necessary, ordinary necessary?
Ordinary and necessary expenses. Thank you, Your Honor. That's very helpful.
And you may have other issues.
The gift question I don't actually have a great deal to say about because it's such a straightforward question. The legal standard of a gift, and it doesn't matter whether you go to our cases or you go to Ms. Bobrow's cases, I don't think, the gift has to be based on the intent of the giver. It isn't based on whether the person who received the things intended to pay it back or not. And the Berger case even says it's got to be clear, unmistakable, unequivocal intent in a situation like this where there's really a dispute with the person who made the gift over whether they intended to make a gift or not. Under the circumstances here, I just don't think there's any way you could conclude, knowing how family court cases go, that after the filing of the petition, Mr. Bobrow intended to make a gift to Ms. Case, especially when he then came into court and said, no, I didn't. I want to get paid back for that. I want some kind of an offset. I just don't think there's any way you can support that factual conclusion.
What does the record say about what his intent was in making those payments toward the house and toward the car? I mean, what was his purpose? What was his motivation?
His purpose was he didn't want to leave her out homeless because he recognized that she didn't have a great deal of cash on hand. And so he was essentially making advancements. I'll tell you today, he's still paying the joint expenses of that Estancia house. And there's a whole separate court case about that because he doesn't want the house to go into foreclosure. Those things have to be paid. And so, no, he didn't cut off her health insurance. He didn't refused to make her car payments, but he always thought he was going to be repaid, that there would be an accounting for those.
And maybe I'm just not clear based on the briefing. In the pretrial statement, you asked that your client be reimbursed for half of the medical insurance, the car payments, and all of the expenses relating to the marital residence.
And the marital residence is by far the bulk of them, yes.
Correct. But on appeal, you've only requested the car payments and the expense on the marital residence, correct? I don't see anything in your brief that asks for us to.
That's possible, Your Honor. My intent was to ask for whatever it was we were asking for in the trial court. I did not intentionally leave those out. However, I don't think that's going to be a large amount of money if that's the difference.
Okay. And then do we have a set amount that entails? I mean, was there evidence presented to the trial court where we can just look in the trial record and say, oh, it's X dollars?
There was evidence presented. There is a timing problem in that the decree comes out somewhat after, so he's got another month and a half, 2 months of expenses at that point that he's paid. And the court below has treated the pre-decree expenses very differently from post-decree expenses, which it's refused to get involved in. And so if you just base it on the evidence at the time of trial, you're leaving him stuck for a couple of more months of expenses.
Well, what are the numbers?
The number I believe that was used at trial was approximately $77,000.
For both home and car?
I believe that's what he was asking for, Your Honor.
Home, car, and medical insurance, or just home and car?
I don't know that, Your Honor. I would have to double check that.
Okay.
The ordinary and necessary expense issue, and I will make a clarification. When I originally, I think it was in our opening brief, said to send it back and let the court redetermine this because they determined it under the wrong standard. And I think that's absolutely true. It clearly was determined under the wrong standard. At that time, I was not able to figure out exactly what the trial court done, and so I said, and by the way, also make sure that the trial court gives him credit for his allowance that was based on a $50,000 a year number. You're familiar with what I'm talking about?
I do.
Yeah. Ms. Case came back and said, well, in Exhibit 2, she gave him credit for that. And that is true. She gave him credit for that. Initially, I wasn't able to determine whether the trial court had given credit for that. In preparing for the argument today, I think I finally figured out what the trial court did, if you want me to try and throw that out there, if it would be helpful. If you think you know what the trial court did, I believe what the trial court did, in footnote 3 of the decree, it says that Judge Whitten says, I have deducted several things, including, and gives a short list. It actually, if you go to Exhibit 2 and you take the exact things that are on the list, those are the things he deducted. And if you then deduct the $50,000 a year allowance money, you get the exact number, 120. So you can, in fact, look at that list, which I did not think it was true, but you can, in fact, look at Exhibit 2 and determine exactly what was awarded to her.
Just those items plus $50,000 a year through the marriage, or only after the allowance began to be given?
The
latter.
$50,000, there are two $50,000 a year figure. The $50,000 a year post-decree is stipulated that he will
Right.
continue to make that, and he is making that.
Right.
Pre-decree, that was just something that he did. He said, I think this is an amount you can have, and he did that up to the point where the petition was filed.
Okay.
And that's given credit in Exhibit 2.
That is given credit in Exhibit 2, yes.
What was the, I mean, did your client argue in the trial court that it is wrong to assume that if I didn't object to a particular expense in year 2 of the marriage, automatically, if it was incurred, I am liable for it?
Well, the premarital agreement says that. It has a non-waiver clause in it. My client certainly said yes. There's a whole series of questions about, did you think that just because she did or didn't present something that you were going to have to pay it back later? And he says, no, that's not what I thought. Church expenses are a perfect example. If you look at Exhibit 2, you've got church expenses going all the way back to 2003. If those, it's her church.
But did he make the argument that I didn't object to them because you were going to pay them?
I believe so, yes. I mean, I think the evidence in the trial court shows that there wasn't a great deal of back and forth. There may have been a couple of times when he asked her to pay something back. I mean, if he paid something, he paid it. But he didn't think he was establishing a precedent that then he had to pay it forever.
Or that if he didn't object to it, he had to pay it forever?
Exactly, Your Honor. And so you've got things in that list, Exhibit 2. Very top of the list is her separate business expenses. How can that fall within an ordinary and necessary living expense?
Did he argue in the trial court that she was somehow stopped or latches applied to bar her from coming back and asking for an expense she incurred in the early years?
There were no arguments at the end of the case, so I would have to look at the pretrial statement. I don't recall if the word estoppel was used, but certainly that was the...
I didn't find it, and nor did I find him citing to the statute that says that it's a viable defense, 25205. And why wouldn't he? Why would we allow the Superior Court to have to go through 10 years of marital records to resolve such an issue?
Well, I think you have a number. There are several pieces to that question. One is, if you look at Exhibit 2, she really is talking about stuff going all the way back to 2003. So the whole question that, he always paid my church donations. Well, no, he didn't. The whole list is right there going back to 2003. So how do you even get there? Realistically, even if you adopt the trial court standard, which I don't think you can under the terms of the premarital agreement, but even if you adopt the trial court standard, the trial court said something changed in 2012. Why is he being charged with things going back to 2003?
But is your current position on appeal about these amounts is that they should, in whole or in part, should not have been allowed to her for reimbursement?
There's, I think, $500 worth of food out of the $129,000 that was awarded to her. He would probably concede that he's required to pay the $500 worth of food. But there are large categories that are clearly not ordinary and necessary living expenses. If
You're not objecting on the basis of, this is a long time ago and it's too late to figure it out. You're saying that some of these were not the kind of expenses that
I do object to the long time ago in the sense that it's contrary to the trial court's reasoning.
Yes, I understand.
But I don't know. If he somehow didn't pay for groceries one day, I think that's a strange thing to be litigating at this point, but that kind of de minimis thing is not what we're objecting to. If I can reserve what I have left. Thank you.
Thank you.
Good morning, Your Honors. Thank you. May it please the Court, I'm Ann Tiffin. I'm here for Pam Case, formerly known as Pam Case Bobrow. With me, I have my colleague, Steve Wolfson, and my client, Ms. Case, is here.
Counsel, before you begin, I would have asked Mr. Arpad, but he was kind of getting short on time. If we think that 25-324 on the fee question is in play, is there a more current affidavit of financial information available to us, or in the record, or in the trial record?
Thank you for that question, Your Honor. May I please, just before I answer that, may I please clarify with the court, will I be permitted to reserve some of my time since this is a cross appeal?
That's a good question, and you may.
Great, thank you. The answer to your question, Your Honors, we're aware that Mr. Bobrow has filed a motion for judicial notice pertaining to financial condition. Under the rules, our response to that is due on Monday. And in all honesty, I'm not prepared to address that today. I've spent all my time getting ready for that.
I just wonder if we were to look at the parties' financial circumstances sort of now, is there something for us to look at?
There is not at this time. There is? There is in the trial court. There's not before this.
That's really what I'm asking.
Okay, yeah, there is in the trial court.
And we've asked for those records.
Okay.
We've asked the court to send up.
Okay, good. Yeah, well, then that will give you the current information. Great, thank you. Unless the court has questions, I plan to spend my time on the snowmass issue. And to that end, I would like my colleague to, what I'm going to use here, I'm going to do some talking about the provision. It happens to be the same provision that's on page 9 to 10 of my client's answering brief. So I recognize you probably can't read it from there, but what I'm going to do is do a little bit of walking around the provision, and you can follow along on the brief if you want. Let's see, make sure I got all the house cleaning items done first. Okay, so this provision gives the husband 3 options, and it outlines them 1, 2, and 3. What's clear under these facts, because the husband chose to sell the property in 2007, what's clear is that only option 3 remains. That's clear for 2 reasons. First, only option 3 relates to a sale. If, as husband appears to be contending, options 1 and 2 also apply where there's a sale, then either all 3 of them would say you can sell it and do this, or none of them would say it. The fact that only item 3 says it indicates that only item 3 applies where there's been a sale. I might add, moreover, that if 1 and 2 applied where there's already been a sale, 3 wouldn't be necessary, because 1 and 2 outline pretty much the universe of potential options. So 3 is applicable for that reason. The other reason that 3 is the only one that can apply is that 1 and 2 both depend on a defined term of equity, which in turn depends on an appraised value.
Say that again.
1 and 2 both require payment based on equity, which is defined in the agreement as based on appraised value.
But so would 3.
Do that too?
But so your point was 1. You said 1 and 2 were the only ways, but that's not true, because 3 could be
true. I'll move ahead. I'm going to come back to appraised value, but let me move ahead and answer your question. 3 provides 2 paths. If the property doesn't sell, then you again use the artificial construct of 1/2 of an appraised value minus the lien. If the property does not sell, that clearly establishes that if the property does sell, that's not what you use, or else the agreement wouldn't say if the property doesn't sell, that's what you do.
But it says if it sells, husband pay wife 50% of the equity.
No, it says if the property does not sell.
Oh, okay. The property is not sold.
But even if let's focus now on the third one. Even if he had had the property at the time the petition and he elected to list it for sale,
Right.
under that third provision, she's not entitled to the half of the proceeds. She's only entitled to half of the equity, which is defined.
I think, Your Honor, is incorrect in that.
Well, where does it say she's entitled to half the proceeds?
Well, where does it say she's entitled to anything?
It says, here's what it says. It says, husband shall list the snowmass property for sale, and I'm paraphrasing a little bit. And
Well,
if,
let's not paraphrase. Let's read it directly.
For a period of 2 years. And if the property has not sold within that time period, then at the conclusion of 2 years, husband shall pay to wife 50% of the equity with 10% per interest from entry of the decree, if the property doesn't sell.
Where do you read the consequence if it does sell?
If it does sell, there are two reasons that the payment is made from the proceeds based on the actual sale value. One reason is that the provision, if that was going to be what he pays regardless if the property sells or not, it wouldn't say if the property is not sold. And the second reason is that only makes sense. The reason for
it makes sense if the fundamental principle is the wife is entitled to half of it, but where do we get in this clause that fundamental principle?
Partially because, again, if the property is not sold, then they go to an artificial construct. The best indication of value is what somebody is willing to pay for it. We have a sale price here. And if the husband had sold it upon the decree, we'd have a sale price and we'd have proceeds. You don't need an artificial construct of half the equity on an appraised value that isn't in the record if you have sale proceeds.
So your position is that a wife is entitled to half the sale price?
Correct.
With no deduction for the lien?
No.
Oh, okay.
Yeah, clearly.
She's entitled to the equity in the property.
Correct,
The equity
correct,
in the property.
correct.
Okay.
Based on the sale price.
So is this argument, I understand your position to be that the starting number is the actual sale price in 2007.
Right.
And Section 3 does not apply here, so that husband is not allowed to, well, it does apply here. I guess I understand the relevance of of what you're trying to say by saying that Section 3 is the only applicable option.
Because Section 3 clearly requires payment of half the proceeds of sale.
That's where you get to half the number right now.
Correct.
The down payment
Minus the lien, but half the proceeds of sale, and payment should be immediate. I'm going to go on and say that this makes sense because the whole idea of an artificial formula based on an appraised value that's not in the record is because otherwise how would you know the value? On our facts, we know the value. The property was sold. We have a sale price. The best indication of value is what somebody's willing to pay for something. So we have a value. So the amount owed under this provision is clearly one half of the sales proceeds minus the lien, the equity. And the payment should be immediate because the reason under item 2 for periodic payments was clearly because item 2 did not contemplate a sale, and therefore there wouldn't be a pool of cash from which the payment could be made. So that's the relevance of item 3. Item 3 being the controlling item leads you to both. Sale.
I didn't read it that way. I read the second clause of 3 to say if it hasn't sold within 2 years, then this is the payment option. He has to pay 50% of the equity in the home with a promissory note for the remainder. That he still has the option under 1 and 2 to elect those payment options.
Your Honor, the reason I think that's not correct is that 1 and 2 don't refer to sale. It's a progression. He can either pay her right away as
equity, which is what the intent of the parties was.
Well, the equity is defined as the appraised value. We don't have an appraised value in the record.
Well, do you want it to be appraised value or just the equity in the home?
The equity as defined, as normal people define it, half the sales proceeds after the lien.
Right. That's what I'm assuming. So I'm assuming that you don't want us to say that that's controlling. Otherwise, wouldn't we be required to focus on what the appraisal was at the time of the dissolution?
Well, I must not have made my position clear because that would apply only if it hadn't sold. If it does sell, then absolutely one half of the equity as we ordinarily define it, that half the sales proceeds after application of the lien. That's what she should get. That's what the trial court found she should get, and this court should affirm that finding. This court should also reverse the option for periodic payments because that option doesn't apply in the case of sale. When you have a sale, you have ready funds from which to make the payment. The idea here was periodic payments if he didn't sell because it would be easier for him to pay it out over time when he didn't have a ready pool of funds. But here he does.
Well, does the record support that? Does the record support that husband put the sales proceeds in the bank and that they're ready to be drawn on in the event that the marriage falls apart 5 years later?
Well, first of all, I believe the record does not indicate. I believe the record doesn't indicate exactly what he did with the funds. But second, that was his choice. It was his choice to sell it in 2007. The reason we're here
At
is
the height of the market.
At the height of the market, and he
for both of them.
pocketed and had the use of those funds. So immediate payment is both, in my opinion, required by the agreement and makes sense because he pocketed and had use of the funds for all those years. That, is the court interested in hearing more about the lack of, well, I want to address it anyway. There is no appraised value in the record. And the husband's testimony did not support what counsel told you that it did. At page 123 of the June 13th transcript, husband was asked, question, in your premarital agreement, Ms. Counsel told you that reference was to the pretrial statement. It's not. In your premarital agreement, you indicated that the value of the home at the time of your marriage in 2002 was $2.5 million, correct? The answer was yes. I think that's not correct. I don't think the premarital agreement states the value, but the value in 2002 isn't relevant to anything. So he claims there's a value in the premarital agreement, but that isn't relevant to anything. At page 126, he is asked, do you believe that your Snowmass property today is worth the amount he received for it in 2007? Answer, no. His belief is also not an appraised value. And if he had gone on and said, no, because I've read the appraisal, then obviously the hearsay objection would have been made. We didn't have the opportunity to make that because he didn't testify as to hearsay. He testified as to his belief. The word appraisal was never used. We have our cases in our brief showing you that the pretrial statement's not evidence. Listing an exhibit doesn't make it evidence. Had it been offered, we would have objected on lack of foundation because the appraiser wasn't listed as a witness.
Well, so there was a value for the property listed in the pretrial statement?
There was an appraisal listed as an exhibit in the husband's portion of the pretrial statement.
Exhibit list.
In the exhibit list.
But the
statement included no
agreed value.
or any asserted value.
Did his portion include an asserted value?
It may please the court, both parties attached what are called position statements, and there was an allegation regarding husband at that time's belief regarding the value, but the rest of Ms. Tiffin's comments are accurate regarding what was put into the record and what wasn't put into the record.
Well, but did the pretrial statement then go on to say that she didn't agree with his presentation of what the value was?
Well, wife disputed that there was any relevancy to the assertion regarding any appraised value years later because of the preceding sale, and there was never an opportunity to pursue that evidence any further because, as Ms. Tiffin said, the appraiser was never offered as a witness, and the exhibit of the appraisal was never offered before the court. So there was no evidence for Judge Whitten to consider at all regarding...
But if a trial judge is looking at a pretrial statement and one party asserts that the value at the time of dissolution is X, and the other side doesn't dispute that, isn't the judge permitted to take that value as undisputed?
Theoretically, he would be. He never got to that point.
Well, he decided that a different number was what he was looking for at a different time.
Correct.
But if we don't agree with that, and I'm not saying we do or do not, I mean, aren't we looking for whether you guys litigated the value of it as of the date of the decree?
Well, it was litigated, but it was not properly presented to the trial court. So the trial court didn't even get to the point of exercising discretion to look at a different value because there was no additional value in front of the court to consider. The court only had the net sale amount, and that's what Judge Whitten, in his discretion, used as the most accurate indication of value at the time.
Plus, Your Honor, we preserved the objection in the pretrial statement based on foundation to the appraisal because the appraiser wasn't listed as a witness.
I'd like to hear about the gift issue.
Okay. All right. May I please, one more thing on Judge Thompson's question. We have a case in our brief that states that the statements of counsel in pretrial statements are not evidence. The gift issue. On that
What's your
issue,
best case for why a voluntary payment post-petition to support the value of a community asset must be a gift?
Because it's a question of fact whether there was a donative intent, And the trial court should only be reversed on that factual finding if it's clearly erroneous. And there is no testimony by the husband in the record that he did not intend those payments as gifts. In fact, what he did say was,
And while you're looking that up, what Judge Whitten said, though, was not that he found them, he did not make a finding regarding husband's intent. All he said was it was a voluntary payment, which does not indicate that he was not going to request reimbursement for the expense.
well, he did say in the June 13th transcript at page 196 that they're gifts.
Well,
Who said-
no,
who
that's
said-
the ultimate
When you say
finding.
he, who are you talking about?
The
court
judge,
or
the judge,
okay.
the judge.
No, he found they were gifts, but the basis was that he had made a voluntary payment, not that he had made a donation or a gift to the other side. He said, you made a voluntary payment, ergo, I'm going to treat this as a gift.
As if that was all there was to it.
I agree that both the transcript and the ruling indicate that the voluntariness of the payment is why he found them to be gifts. But I also think that you can affirm that based on anything supported by the record. His finding is supported by the record because the husband did not deny a donative intent. And what he did do, for starters, he read from a letter that his attorney had written. This is at page 136.
Offered that letter, correct?
Who offered it?
Your side offered the letter.
Okay, yes, thank you. Thank you for your indulgence. I didn't handle the trial, so. He read from a letter that confirmed his agreement to pay these things and did not request reimbursement. He acknowledged that his attorney's letters did not condition his payment on any request for reimbursement. And he, for example, with regard to health insurance, he admitted that he never requested reimbursement of that, and he claimed that he paid it, quote, as a benefit to her. My recollection is that what I've just told you is his entire testimony on the issue. And I'm sure counsel can correct me if I'm recalling that incorrectly, but that was his entire testimony. So the fact finding that these were gifts is not clearly erroneous. There's no basis in the record to find that it is.
Well, isn't what the court did, doesn't that result in wife getting effectively double payment? Because as to the house payment, as to amounts paid to maintain the value of the community asset. She's going to get half the community asset at some point, and husband is maintaining that asset in the meantime. So to conclude that he doesn't get an offset for that, isn't that not right?
Well, I understand what Your Honor is saying, and perhaps that he should have made sure when he made these voluntary payments that he had some protection for himself against them being found as gifts. But that alone is not sufficient to make this finding clearly erroneous. I'd like to reserve my remaining minute and 48 if I can.
Thank you.
Your Honors, a couple things to clarify, if I may. The record does contain some information about what was done with the proceeds of the Snowmass house. Among other things, there's testimony that $1.5 million of it was put into an investment, and there's testimony about that investment, because Ms. Case also had money in it, that it was non-performing and not doing well at all by the time of the trial. So to the extent we're talking about money being in a bank account, money's not in a bank account. With regard to the evidence on the Snowmass house, I believe it was Judge Thompson was exactly right that issue really wasn't contested. And in fact, you see it even in the Ms. Case's opening brief on page 13. She recognizes that husband was arguing for an appraised value of $775,000, much lower than what the value had been in 2007. That issue wasn't fully fleshed out by evidence because the trial judge understood that positions of the parties on that and chose one of them.
I'm not going to speculate whether the trial judge understood. I just need to know what evidence is in the record. Did he actually testify about an appraised value, or was there an appraisal on the record? That's what I would need.
The appraisal was not introduced as an exhibit, and he did not use the word appraisal in his testimony, I don't believe. I believe Ms. Tiffin said at one point that the best evidence that you'd have of the current value is the 2007 sale price. I don't think any adult today believes that houses have the same value several years after 2007 that they did up to 2007. There's just no way that the trial court could have concluded from a sale price 7 years earlier that in fact was the correct value in 2014. If there was a failure of proof there, the failure of proof was on both sides, and the issue does need to be remanded and dealt with.
Counsel, given the fact that this property was your client's separate property, is it your view that she had an interest in the equity of the house, or just had a right to money that was to be calculated according to a measure that took into account the equity in the house?
I think it is absolutely crystal clear that it is the second choice there. That
was your point to us earlier, that when he sold the house, the money was his. Money's fungible. So he owed her money at some point in an amount that would be calculated according to the value of the house on some basis.
That's exactly right, Your Honor. I mean, the section that we're talking about is titled something along the lines of payments on dissolution. I mean, it's very clear that that's for a dissolution payment. And this is never addressed in their briefs anywhere. There's a schedule at the back that says the Snowmass house is his separate property. There's verbiage throughout the agreement saying that.
I mean, it just suggests to me that the value of the money as of 2007, the value of the money would be different at the date of dissolution, too. I don't know how, but it would be.
Well, in reality, it was. There's no evidence on that in the record. He had a lot less money by that time than he did in 2007. That's true. But what the agreement says is it's the appraised value of that house is what her payment's going to be based on. And there just isn't any basis to say that that's impossible for him to pay that money now, or impossible to appraise the value, or impossible to arrive at the right number.
Okay, thank you.
Thank you.
Ms. Tiffin.
Thank you, Your Honor. Counsel told you that it's in the record what happened with the proceeds of sale, but he didn't say where. And so I can't address, because I don't recall it being there, and I don't think it is, but he didn't say where. In fact, what the record does show in a March 11, 2014 minute entry is that the trial court quashed wife's subpoena where she tried to find out what he did with the proceeds. So the husband obstructed our efforts to discover what he did. The only other, does the court have any other questions? Okay, the one thing I did not address, I've overlooked addressing before, the final point I wanted to make about Snowmass is the interest. And I've cited the Malecki case. I've described it at length in my brief.
If you bring it up, I do have a question on that issue. And that is, if he had died prior to the petition being filed, your client wouldn't have got any of that money, correct?
No, that's not correct, Your Honor. The agreement provides, I don't know if I could find it on the fly, but the agreement.
Trust me, it does say that. And it says what she would get in lieu of interest from the Snowmass property is she would increase the monthly payment to $100,000 rather than $50,000.
Well, I understand what Your Honor is saying. She doesn't directly get anything from Snowmass. That's correct. But the agreement provides the Snowmass goes into to fund the estate and would therefore be the funding for her increased monthly allotment under the agreement. So, yes, indirectly, she would still benefit from Snowmass.
Well, she may have benefited, but if we're talking about interest, she couldn't have sued. Your point is she could not have sued for half of the proceeds at the time of the sale.
That's probably correct, but neither did the wife in Malecki. The trial court in Malecki found that the property the husband had purchased was his separate property, not hers. She didn't have an ownership interest in it, just like Pam in this case. But the court nonetheless found that because once she handed him the check, and it's a little different in that respect.
A lot different. And she not only could not have sued, but she would not have been entitled to it if he had died. And so I'm not sure how you can say that that is a liquidated claim at that moment.
Because the premarital agreement created a 50% interest in her, very similar to the wife's inchoate interest. Well, the wife's is an inchoate interest very similar to the wife's in Malecki, even though the wife in Malecki didn't have the right to get it back right then. But she got interest on it from the date of payment because it was a liquidated sum. The same is true here. Why should the husband get to enjoy all of the use of that money, all the time value?
The prenuptial agreement said he did. It specifically said he got entitled to the use of any profits from his own sole and separate property.
Except
About 30 seconds more, and we need to call.
Oh, thank you, Your Honor, thank you. In the third whereas on page 1 of the agreement, quote, which except for the operation of this agreement. So while it is true the agreement made it his separate property, it also made that interest subject to the operation of the agreement. And the operation of the agreement was to give the wife a 1/2 interest in those proceeds.
Thank you.
Thank you.
Thank you to both sets of counsel for your briefing and your argument. I must apologize for throwing the bailiff under the bus here. I'm sure I mispronounced it, but it's my fault, not the bailiff's fault. We'll take the matter under advisement, issue a decision in due course. Now we'll recess for a bit before we hear our next argument.